Mr. Commissioner, Mr. Harrison's estimate, he's next on the list. His estimate is 60. Oh, Mr. Taylor has a matter as well. I'll just introduce this by saying Mr. Harrison's estimate is 60 minutes. Our lunch break is 12:30. I've encouraged him and others, of course, to speed up or to be fast, but I don't think he may not be able to conclude his questions before the lunch break. Mr. Taylor had another initial matter to address before Mr. Harrison.
I don't have a question, but we did find the regional protocol between Habitat and Compliance for conservation protection. So certainly Mr. Martlin's agreed. I don't know about others, but I'd like to put it in as an exhibit, and it is up on the screen now.
Exhibit number 714.
Thank you.
Good afternoon, Mr. Commissioner and panel. My name is Judah Harrison, Harrison. I'm representing the Conservation Coalition, which is a group of 6 non-governmental organizations, and Mr. Otto Langer as an individual. I would like to start, please, with document number 11 from my list, if you can bring that up, please. This is a document entitled The Will to Protect. It's a report drafted by one of my clients, the David Suzuki Foundation, in 2006. Are any of you familiar with this document?
Yes, I am.
Okay, thank you. And I would like to take you to a specific part of this document, specifically page VII. And I would just like to read this out, a couple of points out to you, and ask whether you agree or disagree, and get some comments from you if you feel they're warranted. So right under Restore the Will to Protect, the first statement says, first, governments, industry, and the public must admit we have a serious habitat protection problem. The DFO and the provincial government must acknowledge that current habitat conservation protection strategy is resulting in widespread and in many cases permanent loss of fish habitat. My question to each panel member is whether you agree generally that we are, as we speak, permanently losing fish habitat, and specifically within the Fraser River Basin. Are we, as we speak, permanently losing fish habitat?
In my experience, through working on the Fraser River for 20 years and through staff who continue to work there, there is a loss of fish habitat. I don't know that I would, part I would maybe not agree with is it's permanent. Some of it is. Some of it probably could be restored. Some of it is being restored. We have habitat staff that do work on projects to help restore some of it. But generally, I would say there has been probably a slow net loss of fish habitat in many areas.
Mr. Steele or Ms. Bombardier?
I would say I generally agree with what Mr. Nelson has said, but understanding as well that my direct knowledge of the situation on the Fraser Basin is quite limited. But from what I've heard and what I understand, I would generally agree with what he had to say.
Thank you. Ms. Bombardier?
And I must say that I don't have the expertise nor the knowledge to comment on that from Environment Canada enforcement perspective.
Right underneath this passage, the report makes a number of suggestions, and that's right under Improve Habitat Protection and Policies and Regulations. I would just like comments from each of you on these suggestions and whether you think they are good suggestions or not, practical. And I guess I'll go over each very briefly for you, but the first one would be to clarify government responsibilities. Do you feel that that's a need? And I guess particularly with respect to section 35 and 36, and does anyone on the panel feel that there's a need, that we need additional clarification on that?
I think within agencies there's clarity, but from some feedback I get, I think the public is sometimes not as informed. So I think providing information and communications and education with the public could help improve that. I would say internally, I'd say it is fairly clear. Perhaps publicly it's not.
And actually, I'll just focus on 3 of these suggestions. The first one is establish enforceable conservation objectives. If each of you can give your opinion on whether you feel that that is a valid and helpful suggestion or not. And if you don't understand what that means, then perhaps you can say so.
Yeah, it's a pretty broad statement. You know, a lot of what we have is enforceable already. So I wouldn't feel proper in commenting further than that.
Does anyone else feel that conservation objectives must be established and enforceable?
Yes, I would agree with that. Obviously, it would be a good idea to have clear conservation objectives, and from a practical sense, those would have to be enforceable. I think often where we run into problems is not necessarily the enforceability so much as the capacity to achieve a credible level of enforcement. But the statement itself, I would have no difficulty with.
Thank you, Ms. Bombardier.
I would agree that to achieve objectives for protection, conservation, enforcement is key. Enforceable provisions, definitely yes.
2 more of these that I would like to specifically put your attention to is, one is implement a formal audit process for self-regulating industries. We've heard repeatedly that EPMP is moving towards a more self-regulated state of regulatory affairs, and I would like each of your views on implementing a formal audit process of this.
I would agree that that would be a good process to follow. And I've promoted the ideas of some kind of a formal audit on a number of other areas of the department as well. So I think when we make these operational statements and provide them for habitat protection, in my view, it would improve our compliance if we had a clear formal process that would take a sample and check up on those areas, not just ones that have identified, but random areas. Take a geographic area and randomly do an inspection of it to determine people who are working in there that we have knowledge of, and those that we don't have knowledge of.
Sorry, I just want to go further with that. I mean, yesterday we heard you say various things, including that you're in the field less, and generally fishery officers are in the field less, and just walking around as they used to be was one of the primary deterrents. Would you agree with that?
Yes, as I said yesterday, officer presence is a primary tool in compliance, and the new approach has reduced that aspect, but it has increased in other areas such as the operational statements and working the push towards working more with industry on compliance.
Thank you. Mr. Steele, Ms. Bombardier, do you have any comments on the need to establish a formal audit system of self-regulating industries?
Well, I would agree that self-regulation should go hand in hand with an audit process, and the more there has to be a certain level of formality to that process for it to function properly. I would agree with that.
Ms. Bombardier?
What I could add is that under current regulations that we have, there's monitoring and reporting requirements, and so that provides the industry the ability to monitor, to audit, basically to audit their procedures, their processes, but we're there to check and make sure that it's done and the objectives of the regulations are being met.
Your last statement that you're there to check that the regulations and what they've said is being met, I guess it's my understanding that a formal audit system would meet that need, and I guess make it more random and make the checking of such statements more often, and such information they would do. Is that your understanding? That was not a very clear question, so I apologize for that. But basically what I'm asking is, So do you feel that there's a formal audit process now that's sufficient for what you just said, the reporting of these industries?
The self-audit process is included in the regulations, but as I said, because the provisions are enforceable, we do our proper verification to make sure that the standards are being met.
And my question then is the verification being done by DOE or the Department of Environment right now, is this sufficient to ensure that self-reporting industries are meeting what they say they're meeting?
Yes, I believe so, yes.
Okay, thank you. The last suggestion in that note that I wanted to just bring your attention to was there's a comment that we should make those that destroy habitat pay for recovery. I would like to just hear if that's often called the polluter pays principle, and there's various documents and laws where Canada states that this is one of the principles that guides us. Do you, the three of you panel members, agree that this is a principle that should guide habitat management?
Yes, maybe I'd start by saying any proponent, whether they be a habitat or a fisher, they're doing risk versus reward assessments on their own as well. A logging company, for example, who's pushing a road into an area, if their risk is very low that it'll ever be found, they might take that chance a little more. So, and when they are caught, I think it is important to hold them accountable through whatever means it be. Court being one solution, but there are many others that can get you to the same place. As far as making it easier to hold them accountable, I think we have the tools, perhaps not enough tools.
Thank you. And Mr. Steele and Ms. Bombardier, the principle of the person who, or the entity that destroys habitat being forced to pay for the recovery of that habitat, would the two of you agree that that's a principle that should guide habitat management?
I would say it's a reasonable principle, but would have to be applied in consideration of the circumstances in each individual case. It may or may not be appropriate, depending on the level of the damage, the intent of the individual, those kind of considerations. I think it would have to be looked at on a case-by-case basis.
Ms. Bombardier?
I believe that it's a key principle in environmental protection legislation, including the Fisheries Act and the Canadian Environmental Protection Act, yes.
Thank you very much. And is this a principle that we are certain that we are currently implementing? Is my question. I mean, currently in the Fraser River Basin, if someone destroys habitat, are they forced to pay for recovery of that habitat?
Yeah, in some cases, yes. The case I mentioned earlier today about in the Shuswap lakes, through creative sentencing under Section 79(2) of the Fisheries Act, often sentences are levied that will hold the person accountable and help restore the habitat. In a few cases that we've had using restorative justice, we've also achieved the same goal, whereby the habitat was restored and funds were put towards, substantial funds were put towards habitat restoration.
Okay, thank you. I believe it would be appropriate to mark that document as an exhibit.
Exhibit 715.
Mr. Nelson, yesterday you gave an example of an oil spill, and you said in the case of an oil spill, this would be a deposit of deleterious substances, and it would be an Environment Canada matter. In my view, an oil spill would most certainly result in violations of both Section 35 and Section 36, often. And my question to you is, how often do proponents get charged under both sections of the Act?
In just an oil spill, or
No, generally, how often it,
Okay.
yes.
For clarity, oil spill is is Environment Canada's responsibility. Once it's determined that it could impact fish habitat, then we get involved as well. If it's a harmful, if oil gets on the beach, etc. So there are many cases where persons are charged under both Section 35 and 36. Was that?
That's the thrust of my question.
Yes.
Thank you.
Yeah.
And then I guess if there's many cases where if that is often the case, in your view, is it efficient to have two separate agencies administering those two separate sections?
In the many cases I'm talking about DFOs, where we often, when you have under Section 36 are silt sediment deposits, often those are directly related to a HAD under Section 35. As far as oil spills or chemicals impacting fish habitat, in my experience, those haven't been as frequent. There have been a couple or three in my career, but they're not that common.
I guess I would like to ask Mr. Steele and Ms. Bombardier the same question. Do you feel that if it's the case that many violations would be or many occurrences would be a violation of both Section 35 and 36, is it efficient to have them enforced through two different agencies?
I think it's working quite well the way it is now. I mean, we've had cases, one in Alberta where there was a major oil spill, bunker sea oil in fish-bearing water. There were charges under both 35 and 36, and it was successful conviction.
Mr. Steele?
I would agree that it works generally quite well under the current arrangement. As we discussed yesterday, I think sometimes it leads to some confusion on the part of the public and others as to who's responsible, but for the most part, I think the current arrangement works reasonably well.
And I guess I would ask you on that answer, in your view, would it be more efficient for the two sections to be administered under a single agency?
Would it be more efficient? It's difficult to say without doing a real detailed analysis of the practical aspects of the issue, how it actually would be rolled out under one agency, what sort of transfers of resources would be required from one agency to another, and what the impacts of that would be on the agency that would be giving up resources. So I think without having done that analysis, it'd be premature to make a comment on that.
Okay, thank you. Mr. Registrar, can you bring up Exhibit 691, please?
Mr. Commissioner, when I forgot to simply make a remark for these hearings that I ought to, which was to request that as counsel ask questions, if they're in a position to direct the witness to direct their question to a particular witness, that may be of some assistance, and it avoids the witnesses conferring to determine who should answer a question. So I'll simply make that, and that's not particular to Mr. Harrison, that's for all counsel. Thank you.
Thank you. So this question is for Ms. Bombardier. This document, which was made an exhibit earlier this week, is the interim operational working arrangement of Section 36.3. Are you familiar with this document?
Yes, I am.
Now, within this document, and unfortunately I don't know exactly where, but within it says that Environment Canada has agreed to take enforcement of 36.3, but they will only do so in cases where there has been an identified and significant deposit of deleterious substances. And I emphasize the words identified and significant. Ms. Bombardier, is there a definition, is there any clarification on what is termed or what is meant by significant?
Not that I'm aware of.
And in your understanding, does the Fisheries Act use the term significant when it speaks about violations for the deposit of deleterious substances?
Sorry, can you repeat the question, please?
The Fisheries Act itself are you aware of whether it prohibits the deposit of deleterious substances or prohibits the deposit of significant deleterious, or prohibits the significant deposit of deleterious substances? Is the word significant in the actual act itself?
Not under 36.3, no.
In your view, and am I right to understand then that this is a policy of the Department of the Environment to not enforce many incidents that would otherwise be a deposit of deleterious substances?
No, we look at all incidents, but the priority for action depends on a number of factors, including other partners' roles, jurisdiction, in the situation at hand, the level of harm or the risk of harm to the environment, in fact, a number of factors that are taken into account before a decision is made to go on site or to perhaps look at partners and see if what their intentions are.
And I guess it's fair to say then that only once it's determined that significant harm has taken place would any of that investigation or compliance occur, or compliance monitoring occur. Is that fair?
No, there are other factors, including repeating offenses. So it's not because it's a minor spill that it means that we won't go. If there's a fish kill, if it's a repeat offense, if we have experience with the offender in the past that suggests that there's a chronic problem, we'll definitely go on site and check.
Okay, thank you. Mr. Registrar, can you bring up document number 3 of my list, please? Now, this document is a email between various DFO staff, including Sue Farlinger and Alison Webb, who was then director of the Aquaculture Division. The email stems from 2005, March 10th, 2005, and the earlier exchange is from March 9th, 2005. Is anybody on the panel familiar with this document? And I note that none of you were included in this email exchange.
On the portion I can see, I'm not familiar with it. This is before I was in my position, so I wouldn't have been included in it if it's from another area.
Okay, thank you. I actually didn't expect anybody to be familiar with this document, but I bring it up for the purposes because I think it shows a manner of acting that is disconcerting, to say the least, and I would like to hear your opinion on that. In the March 9th portion of the email, this is from Patty Menning, she discusses visiting Shaw Point, and near the end of her email she says a couple of things, including, I am somewhat uncomfortable conducting compliance sampling with the province for this renewal site without senior level support and direction.
Mr. Commissioner, I raised the concern, and other participants may have views on this, that this would seem to speak to a particular site and also to get us into the territory of aquaculture on a particular example. I also raised the concern that I don't expect these witnesses have familiarity with the topic or in particular the compliance sampling that's referred to there, 2005 Shaw Point. So those are a few reasons why this may be a difficulty. I don't know if there's perhaps a way for Mr. Harrison to step back from the particular and approach at a broader level the subject matter or the question that he's looking to raise.
And in response, I will just say that I only intend to focus on the principle expressed in this email. And that is, my question is, before conducting compliance sampling and the need to obtain direction from senior level, is this a common occurrence? Is this a common situation? Is it often the case that people, your staff, Mr. Nelson, would seek permission or direction from upper level senior management to do compliance sampling?
I honestly, I'm not familiar with the name Patty Menning. The name Barry Kanister is a fishery officer, and I know Alison Webb. So the person who's writing this, it's not an officer, but they could be a DFO employee. I'm not even sure of that.
And picking up on Mr. Martlin's concern, I'm not interested in putting this to you for the actual incident that took
Okay.
place, but it's more for,
Yeah.
to me, it was disconcerting to see DFO staff not willing to take compliance sampling absent direction from senior levels management. And I would like to ask you, first, if that's common, and second, if that's appropriate.
Not in any of my experiences. Staff certainly should be assured they have proper training to take sampling, because there's some pretty nasty things out there that we encounter, and they have to have proper sampling training. I don't know if that's partly to do with this. I have no idea what the case is about. As far as requiring, do I believe an employee should require senior management approval to collect, gather samples? In staff report to me, if they have the training, there's an occurrence reported, and they can approach the site safely and conduct their investigation, they do. I don't know that I've ever been asked by any staff that should I go out and do some sampling. It hasn't happened to me.
Okay, thank you. Mr. Steele and Ms. Bombardier, would you think it appropriate that in order to do compliance sampling, staff members should obtain permission or directions from senior level management?
In the case of Environment Canada, as we discussed briefly yesterday, we have an internal decision-making process that outlines who needs to seek what level of approval before they conduct enforcement activities. When we plan our inspections, that's done at the manager's level, so the managers need to approve the inspection plan. Because of health and safety reasons, make sure we're consistent with the national priorities. So the planning itself is done at the management level, but once the plan has been established, staff, they have the training, they have health and safety equipment, and they go and do their own the activities as it was agreed.
So my understanding of your answer is that DOE staff will require senior management direction or permission to do any compliance sampling. Is that correct?
No, once the plans are established, the targets have been identified, the staff go and perform their activities. It's at the planning stage that it's approved, but then staff conduct their own activities, and including sampling.
I should add, I just thought of one case where I was contacted, not about a sampling procedure, but it was an area of the province where we don't have Fisher officers located, and I was contacted by staff to confirm that they could go conduct an investigation. So that's somewhat related, but not really, because it was outside of what their priority should have been.
Okay, thank you. I would like to mark this as an exhibit, if that's appropriate.
Well, I'm not agreeable to that. None of the witnesses can identify this document. None of the witnesses were involved. It deals with a particular point called Shaw Point. That's not, I don't know where it is, but even if it's within the Fraser watershed, it's not relevant to this. And we now have a document that's part of a story that no one knows anything about, that has nothing to do with this other than it was used as a springboard to get evidence about whether staff do or don't go to their superiors to get authorization to sample. And the witnesses have given evidence about that. We don't need the document, and it's inadmissible as well, in my view.
In response, I would say that this document shows a trend that is clearly relevant to enforcement, and I put this to them and ask them, and it is therefore relevant to proceedings.
Well, there's no trend shown, and they refuted it.
Yes, I think Mr. Taylor's points are well taken, but in interest of ensuring the record is kept straight, let's just mark this with a letter for identification purposes. If Mr. Harrison can come back later with sufficient groundwork to establish some direct relevance of this document, it may then be marked.
This document will be marked as letter X for identification.
Mr. Registrar, can you bring up Exhibit 693, please? This is the 2001 Compliance and Enforcement Policy for the Habitat Protection and Pollution Prevention Provisions of the Fisheries Act. Are the panel witnesses familiar with this document?
Yes?
Thank you.
Yes, I am.
Yes.
We've heard talk, repeated mention of the toolbox of responses and potential responses that both DOE and DFO has with respect to enforcement, or whatever the term be. Is it your understanding that this document is the genesis of that toolbox, in listing out the toolbox?
The tool, such as directions, is actually a legislative tool. It's in the Fisheries Act. That policy outlines how it is to be used.
Sorry, my question was off target. What I would like to, there's been repeated talk of, I guess, the approach that is taken by both DOE and DFO to the toolbox, including that prosecutions will be brought as a last resort, if that's fair. I would like to know if this document is the genesis of that approach to the toolbox.
For Environment Canada, yes, it is.
And Mr. Steele, do you know if, for the Department of Fisheries and Oceans, if this document is the genesis of the approach to the toolbox to use enforcement as a last resort?
I'm not really sure what you mean by the term genesis. Are you asking whether that approach was in effect before this document was created?
I'm asking if this is the first time that a written policy was taken with respect to using prosecutions as a last resort.
I'm not sure if there may have been pre-existing policies that stipulated the same general principle. I'm not really sure if this was the first time that was stated or not.
Okay.
Now that I understand your question, under CEPA, there's a compliance and enforcement policy for the Canadian Environmental Protection Act. And that policy, I believe, existed before the Fisheries Act existed, and that approach is similar.
Okay, thank you. If you could turn to page 6 of this document. This is a question for Mr. Nelson, and the bottom of page 6 and the top of to the middle of page 7. I guess it's better to go to the middle of page 7. There's a list of powers of inspection that a fishery officer and guardian has, and I'm wondering, we've heard repeated reference to certain powers, inspector designation, being taken away from habitat staff. Are these the powers that are being removed?
I'd have to look at the section of the Fisheries Act, but are these maybe powers under what a fishery officer has? I'd have to look at the exact section.
So, we've heard repeated reference to inspector designation being removed from, and being given only to CNP and removed from various habitat staff. Is that correct?
The inspector's powers of non-fishery officers is being removed, yes.
So, my question then, of the list below, are these the powers that are being removed? And I see Mr. Taylor shaking his head, so maybe I'm wrong in this. But my question is, are these powers that the staff had and will no longer have?
I'd have to have the Fisheries Act in front of me, but I think some of these are regular fishery officer powers. Mr. Steele may be able to answer.
No, I think what's laid out here are the powers of either fishery officers or fishery guardians under the Act. The intent is to remove the inspector designation from the habitat staff, but they would that would be removed, but they would be given fishery guardian status. So those powers that are listed there, they would still retain. The difference is that they would not be authorized to issue inspectors' directions under the new scenario.
Question for Mr. Steele and Ms. Bombardier. Is there any policy or direction with respect to when you move from one tool to the next? As we see, there's a policy that clearly lays out the tools, but is there any further direction or clarification of, there's been this many occurrences, there's been this many directions, and we will therefore go to this next step?
I'm not aware of any directions like that on the DFO side.
There's principles that are listed in the policy, like consistency, national consistency. So Our officers, before they take an enforcement action, like issue an inspector's direction to address a particular violation, they will look at similar incidents that occurred across the country and what enforcement action was taken for similar circumstances to make sure we're consistent.
So would you agree then that there's no direction anywhere that a certain number of violations of the Fisheries Act will necessarily result in prosecution under the Fisheries Act?
Prosecution is one tool, and we don't control what prosecutors will want to take forward. So there's a number of factors involved, and some cases will lead to prosecution. As I explained earlier, if there is obstruction, there are circumstances that are listed in the policy that will lead to prosecution. Other circumstances, it's officer discretion, and again, consistency, and whether the prosecutor feels that there's public interest and sufficient evidence to proceed.
Am I correct that among the principles that would lead to prosecution are repeat violations and repeat offenders?
That's one consideration, but it's not one of the guiding principles of the policy.
In relation to your earlier question about inspector status, if you on page 9, page 9 near the bottom, those I believe are the powers that would be lost. Just 4 bullets there.
What I'm trying to get at here is, and I'll ask this directly, if there is a repeat and chronic violation of the Fisheries Act ongoing, would this eventually lead to prosecution necessarily or not?
It may or may not.
As I was explaining, if you look at page 18 of the policy, it talks about the criteria for responses. One of them is the nature of the violation, which include repeated occurrence. So definitely that is a key factor that's taken into consideration. But as I said, prosecutions have to be taken by prosecutors, so we can later charges, but ultimately it's the prosecutor who decides whether there's sufficient evidence and it's a public interest to prosecute.
Are you aware of the Iona wastewater plant on the Fraser River Basin?
To some degree, yes.
Would it be fair to categorize this plant as among the primary polluters of the Fraser River? In other words, is the Iona wastewater plant, does it repeatedly put out deposits of deleterious substances into the Fraser River Basin?
I'm sorry, I know there's been some incidents, but I'm not sure I have the statistics. I don't have the numbers in front of me to confirm that.
There is a document that I want to bring up in that respect, but I'm not going to do that now as I fear too many objections and fear that they will be valid. So I will move on. Mr. Nelson, a very specific question. Do you feel that you have sufficient technical access to technical expertise to do your job? And in that regard, I'm thinking of hydrologists, geomorphologists. Do you have sufficient access to such technical expertise when it is required?
When it's required, at one point we used to have our own water quality unit with experts within the department. That they have not been replaced, and now we must rely more on experts from outside the department to be hired on to provide us that testimony often. We have people that internally that can give us expert testimony that it is fish habitat, but when you get into some of the chemicals, some of the sediment issues, we have lost some of that expertise.
And I was not thinking just for prosecution purposes, obviously. I'm talking just generally when you go out into the field. Am I correct that you may want access and assistance from technical experts?
Yes, we do, and we rely where they are departmental staff that have that expertise. We use them, and where we don't have staff with that expertise, we contract it out.
Okay, thank you.
Just ask, apologize, Mr. Harrison, just one thing. Mr. Nelson, is there a current survey of fish habitat within the Fraser watershed so that if a member of the public is about to embark upon a project, they could get information about where fish habitat may be in the area in which they are planning their project?
This is more of a question for our habitat staff, but there is a mapping system that shows where fish habitat is in most places. Like I think in the Shuswap Lake, for example, there are maps available that lay out where spawning areas are, which are very critical, and there are areas that show where habitat is. But I'm not the real expert on that, but I believe they are available.
We may have that in evidence, I don't know, or it may be in Ringtail. I just curious, you use that term to determine whether or not it is fish habitat.
Yes.
And I didn't know what it was you would go to, or what your staff would be going to in order to make
Right.
a determination.
To determine its fish habitat, it's a very important part before we proceed in an investigation. Sometimes a simple thing like setting a fry trap and catching fish in the water where the violation occurred, or personal knowledge that fish have spawned there. That's another thing. If we know that fish spawn in an area year after year, we don't need to get an expert to begin our investigation. We'll need to bring in an expert in if we go to the prosecution. But it varies in area to area.
Yes, thank you.
Mr. Commissioner, I wonder if I might simply canvass through you with, and also council in the room. My math is Mr. Harrison has 15 minutes remaining, and here's the way our day is shaping up. Mr. Rosenblum's time estimate is 45 minutes. Mr. Harvey's is 15 minutes. Ms. Brown's estimate is 60 minutes. And if I've done my math correctly, if collectively council are amenable to Commission Council really policing their time estimates and working on that set of time allocations, on my math, if we return at 1:30 and do have an afternoon break, we would conclude by 4 o'clock with the panel's evidence. I'm in the Commission's hands whether we run for the finish line or not.
Yes, running to the finish line has often meant stumbling towards it, and so I would only be inclined to cut the time short if in fact those times can be adhered to. I don't know how firm those times are. I'm content to come back at 1:30 if all council agree that we'll be finished off this afternoon by 4 o'clock. Otherwise,
I'll try and frame that as a negative proposition. If any council has a difficulty with that, this is your opportunity to make that point. Otherwise, I will expect that we'll be looking to hold to those times and conclude by 4. We do have 2 witnesses that are here from Ottawa or Gatineau, and so I'm mindful of that. And if there's a way for us to do this, completing today, I think that's preferable to coming back for half hour, an hour on Monday.
I'm going to attempt to do my best in terms of 45 minutes, and I'm very happy to return at 1:30. My question is, in case it takes longer, do we also have the safety valve of going to 4:30 as opposed to 4? Because all of us would obviously prefer not to show up on Monday, and if we could complete it today, all the better. Is there a problem there?
there's a bit of a problem there, Mr. Rosenblum, so my suggestion is, why don't we come back at 1:30, do our very level best to complete these witnesses by 4 o'clock, and go from there.
Whatever.
Thank you.
We'll now adjourn until 1:30.